Good evening, almost good night. This is the last panel. I'm sure this is the last one. You can relax, and I'm under strict orders from the Chief Justice Grunis to keep this short. And for me, retired or not retired, this is a judicial order, so I'll comply. I'm Dolova Sano. I'm a partner in the commercial litigation class action practice in Igor, and our panel concerns with the role of lawyers and funders, ethical issues, and effectiveness for class members. And we're going to do this quite short, and we're going to do this in a conversational kind of way, so not a string of presentations. So I want to start off with presenting our distinguished panelists. Joshua P. Davis serves as a professor and director of the Center of Law and Ethics at the University of San Francisco School of Law. He writes, among other areas, on class actions, class action ethics, and antitrust class action. His work is both empirical and theoretical. Simon Walsh is a senior investment officer at Woodsford Litigation Funding, based in London. Prior to joining Woodsford, Simon was a cross-border litigation international arbitration specialist at Skadden Arps in London. At Woodsford, Simon has a focus on securities and other group actions, both in the UK and EU, as well as Australia and Canada. Chris Chimiclis is a founder and president and CEO of NGN Group. NGN is headquartered in Philadelphia, Pennsylvania. NGN specializes in providing notice, large-scale group claimant administration, and book building services in the United States and Europe. Chris is actively involved in several class action-related funding and book building projects in the United Kingdom and EU. Stephen Weisbrot is a U.S. attorney and the Chief Innovation Officer at NGN Group. He has a background in media planning, digital marketing, and group litigation, and as such has been responsible for some of the largest and most complex class action notice programs in U.S. history. Stephen has given public comment and written testimony to the U.S. Judicial Conference Committee on Rules of Practice and Procedure concerning the role of media in effecting due process notice. Moreover, Stephen is co-author of Duke University Law School Guidelines and Best Practices Implementing 2018 Amendments to Rule 23. And we have Noah Wortman, joined IMF Bentham in July 2018 as Business Development Manager, Global Investor Recoveries, and splits his time between Philadelphia and London with a global remit covering North America, the UK, and Europe, Australia, and Asia. Noah has extensive experience advocating for investors, promoting corporate governance, and implementing strategies to achieve collective redress. Prior to IMF Bentham, Noah most recently served as Managing Director, Americas, and Global Head of Class Action Services in London-based Gold Group. He was responsible for the company's operation and strategic vision in the Americas, and also led the company's worldwide initiative in securities and antitrust class action litigation services on behalf of its global institutional investor clientele. Noah has been a staunch advocate for investors since 1995 and has spent his career in the global securities class action litigation space, having worked earlier in his career at Kessler, Topaz Meltzer, and Czech, and later in London-based Stewart Law as Director of Case Development for the Investor Protection Litigation Department. I want to start off just with two comments on the Israeli, what I would call the Israeli paradox of ethics in class actions. And the paradox is thus. On the one hand, Israel class actions are almost always opt-out schemes, and most of them are for small sums. So the process cannot be financed through the willing participation of class members. Also, the benefits are almost exclusively for the class attorney. So the class representative gets a rather small fee. He has no incentive to finance the process. So we're left with the class attorney. However, the class attorney, from an ethical point of view, is barred from financing the client's costs, both the cost of litigation itself and the cost that might be awarded against the plaintiff if the class action fails. And also, under Israeli Law Bar Act, attorneys are also barred from sharing attorney's fees with someone who is not an attorney. So, hence the paradox, there is a disconnection between who shares the costs of litigation and who shares the benefits. This is the paradox. The enigma is, how come Israel is still the class action capital east of the Atlantic? But I'm going for the defense, so I don't know. I wanted to ask Professor Davis to start it off with guiding us through just one second. Third-party litigation financing might be the solution to this paradox and this enigma. And this is just in infancy in Israel, especially with regards to class actions. So this is something that we are going to deal with. And I want to ask Professor Davis to guide us through the discussion on third-party litigation financing by giving us the theoretical framework.
Thank you very much, and thank you to Ariel and Rabia for inviting me, as everyone has thanked everyone. And thank you all for being here still, if only in body and not in spirit. I'll take what I can get at this late hour. I think we on this panel are all very much aware that this is a little bit like the 17th toast at a wedding reception. It really doesn't matter how good it is at this point, it is still the 17th toast at a wedding reception. So we have made a blood pact to move as quickly as we can. However you think our remarks in fact are, they were brilliant before we boiled them well down, and I'm going to try to do that. So very quickly, I want to start with what I take to be the theme of the day, which is that the American class action system is unacceptable, if only because it is American, but on the other hand, it may be the only system that in fact works. And given that my goals are being brief and provocative, to wake you up a little bit, I'm going to go one step further and say the American class action system does work pretty well, and if it has a failing, at least in the area I know best, which is antitrust law, antitrust class actions, which you might call competition collective actions or something similar, the failure is that it doesn't obtain enough compensation, and it doesn't deter enough. Not that it in fact goes too far. I'm going to lay out a brief case for that and then leave you all in peace. And that the solution, or at least a potential solution to that problem, is third-party funding. And so in fact, what is often taken as an ethical problem that is arising today in our system is a solution, an ethical solution. So to start off very briefly, and I will be just talking about the US system, and I will be talking about antitrust, but in some ways, and I've studied those theoretically and empirically, so I feel most comfortable in them, but in some ways it's a test case, because if compensation and deterrence are insufficient in the US system, in antitrust, where there's automatic trebling of damages. If plaintiffs wins, they win, they automatically get treble damages, and there still compensation deterrents are insufficient, then maybe it's true of the system as a whole. So let me just talk first about the specific issue I want to address in third-party funding, just to define the problem. There are lots of versions of third-party funding, and I'm only going to talk about one, and the one is loans to lawyers as opposed to clients, and loans that are specific to a case and that are non-recourse. So the lender only recovers if the lawyers recover, and secured and contingent in that way. So that is perhaps the most controversial, one of the most controversial forms of third-party funding that exist in the United States. Distinguish that, for example, from lines of credit, where a law firm, which is very common in the United States for plaintiff side class action firms, and not very controversial ethically, which is a firm just has a line of credit, there's recourse against the firm as a whole or the partners individually or perhaps both. That doesn't tend to be a problem, and it's certainly not a legal ethics problem if the client assigns rights to recovery to a third-party funder. Otherwise it may be an ethical problem, but not legal ethics. We think about lawyers. So what happened recently was that in 2018, the New York City Bar Association issued an ethics opinion which cast doubt on this particular form of third-party funding I described, where there's a lender and the lender gives, offers a loan that is contingent and it's non-recourse against the lawyers, it only exists against the case. And what the, quite a few cases, quite a few judicial opinions had approved of this particular structure, but what the New York City Bar Association opinion suggested was that this was improper because under the model rules in the United States, in most, and the actual ethical rules in most jurisdictions, it is not proper for a lawyer to share fees with a non-lawyer. And the New York City Bar Association sent some significant waves through the ethical world by saying this is the improper sharing of fees with a non-lawyer. And what the Bar Association emphasized was that there was too much of a risk of lawyers losing their independent judgment, and I think perhaps the other side of the same coin, a conflict of interest arising between the clients and the attorney. Now, just by way of background, I do want to be clear, my understanding is it's standard practice in these situations for third-party lenders to disavow any control over the litigation. That if they have any sense, in their contract, they say, we're not going to interfere with the lawyer's judgment, but the question is one, nonetheless, I think, of incentives. You could do a formalist argument, is it sharing fees or is it not? I certainly don't have time for that right now. I'm going to assume one could argue either way, and what matters in the end is policy. And what I want to put out there is that, very briefly, to say a couple of things, that in antitrust class actions, the compensation that class members receive is quite substantial, that the deterrence effects are quite substantial, but the best evidence to date, I've done some empirical work, and Bob Land has done some empirical work, and John Connor, and I'm going to just summarize that very quickly, suggests that it's actually not enough, and I want to explain why that is and why this very form of litigation funding may be a cure for the problem and not itself a problem. In terms of the evidence, next month I'm going to be putting out a study that shows that for the past 6 years, on average in the United States, antitrust class action settlements have resulted in a $3 billion recovery per year. So over the 6 years, in nominal dollars, slightly over $18 billion, which is pretty substantial, compared to, say, the zero we kept hearing about in other jurisdictions to date. So there's that. In terms of deterrence, I have a study that I did with Bob Land. I'm happy to go into the details individually. I plan to address them, I will not. But it suggests that even where the Department of Justice, where government enforcement is most effective, which is going after price-fixing cartels, the deterrence effects from private enforcement, measured in dollars, are actually probably greater than the deterrence effect of the Department of Justice. And I'd be happy to give you a citation or talk individually about how we arrived at that number. So why do I say, so that's substantial, that's a real benefit. Why do I say that even though those benefits and compensation and deterrence are significant, they're not ideal, they're not optimal, they're too small? That comes from a couple of sources. I want to give you an empirical basis quickly, and then a very quickly sort of quick theoretical description of why I think it happens, or one key mechanism by which it happens. But John Connor and Bob Land, John Connor has probably the best database on price-fixing conspiracies in the world, and he took that database and he took independent assessments of the likely damages from cartels in particular cases, and he has a fairly exhaustive, within that database, fairly exhaustive information about the actual recovery in private litigation and the sanctions imposed by governments throughout the world. And what they come to the conclusion is that on average, in a price-fixing case, conspirators as a whole pay about 1/3 of the harm they cause or less. There's obviously some judgment calls in there, but it's about 1/3 the harm they cause or less, and that there are very few cases, almost none, where the conspirators end up paying as much harm as they cause. And so they say crime pays, and they've done a fairly rigorous work. You could contest it, but it's fairly powerful. And then if you add one more layer only, which is that not all antitrust violators get caught, we see a significant problem for undercompensation and under deterrence. Now, the key mechanism I want to point out, at least within the US system, is that as ethical as attorneys are, and I really do think that attorneys try to be ethical both on the plaintiff side and the defense side, there's a very unfortunate asymmetric dynamic when it comes to settlement of class actions in general and antitrust class actions in particular. And the dynamic is that the plaintiffs' lawyers expend huge amounts of time and large amounts of money, all of it contingent, and that tends to make them risk averse. They're delay averse and risk averse, and so they want to settle relatively quickly. That's how they profit maximize, even if it's at a relatively modest amount. Whereas on the defense side, the defense attorneys are paid by the hour, and so delay tends to be their friend. And so they have a tremendous advantage in the negotiation process. And that asymmetry, I think, is one of the key mechanisms for why, as robust as compensation and deterrence are in the United States, they're still insufficient. And here enter third-party funding. The form of third-party funding is often of the kind that we care about, a non-recourse loan where the plaintiff's lawyers will get some substantial portion of their hourly rate, often half of their hourly rate up front, and they trade away some of the upside at the end for that, and maybe have some or all of their costs compensated by the third-party funder. And this helps them be much less risk averse. They lose the downside of actually being fully out of pocket at the end of the day, and because they're being paid in part on an hourly basis, they are no longer as averse to delay as they otherwise would be. So there's a very real prospect that this ethical concern is in fact an ethical cure, that third-party funding would in effect give the plaintiff side class action lawyers the backbone that it's hard for them otherwise to have. And the one piece I would add to all of this, and then I will leave you all in peace and move on to the next panelist, is there is often a false baseline. You know, the assumption is third-party funders are interfering with the independent judgment of the plaintiff's class action lawyers, and that if they weren't involved at all, somehow we would be in a pristine state where lawyers care only about promoting the interests of the clients. But the reality is there are always incentives before lawyers, and as ethical as lawyers try to be, they are in fact affected by those incentives. And so my suggestion is that third-party funding may be, in this sense, a cure, and I would suggest also, at least as a matter of experiment, to allow it for quite a while, even in this form that's been somewhat questionable, and do the empirical work and see what effect it has and whether it improves matters or makes them worse off. Thank you very much for your patience at this late hour.
Good evening. Is that on? It is. Hello. Good evening, and again, I'd like to repeat Joshua's points of thank you very much for staying to the end. It's appreciated. My children wake me up at 5 in the morning every day, and the only thing that's on the radio in Britain at 5 o'clock in the morning is the shipping forecast. And I realized after some time that even though I hadn't been listening to the shipping forecast, I could name all of the rocks that the various fishermen needed to know about for their daily weather forecast. So I'm hoping this evening will have very much the same effect on you, that even if you're not actually listening, by tomorrow you might realize that you've actually remembered some of the things that we've said. So I'd like to just follow on from what Joshua said actually about the ethical issues involved in third-party funding. I find it very interesting that many people will accept and agree that collective redress for consumers and others in circumstances where individuals are not able to economically bring claims on their own are a good thing. However, once we enter the question of who should pay for that, it's suddenly a very thorny issue. If you accept you're in a world where injustice will be addressed and not only be available to those who can actually afford it, then third-party funding steps in and seems to be a fairly uncontroversial thing. However, there are normally three ethical issues that are raised, and these feed very closely off what Joshua was saying. The first is that the use of third-party funding has fueled unmeritorious claims. I think it's certainly true to say that third-party funding has provided access to justice for many and has increased the number of claims. We've seen today that the number of claims across the globe has gone up quite drastically in some jurisdictions, and that's in part to the availability of outside funding. But I think there's a very interesting assumption built into the idea that those claims are going to be unmeritorious. I sit here today because the claims that I fund are claims that are in fact meritorious. If I was funding unmeritorious ones, I'd be out of business fairly soon. It's the job of funders, as I'm sure many of you may have been involved in funded matters, to ask lots and lots and lots and lots, and often even more, questions in the due diligence process to determine that the claim is a claim that's likely to succeed. Funders are putting all of their money at risk, and I think I slightly take issue with the term loan and lender used by Joshua to some extent. He did clarify that it's non-recourse, but in many instances, definitely in the funding that funders like Woodsford and others carry out, it's fully non-recourse in that if the claim loses, the fund loses all its money. And that feeds into the question of pricing that I'll get onto. So it's a big risk for funders, and they don't want to throw away millions of pounds quite often on claims that are not going to win on the hope that they settle, because I tell you what kind of answer I get from my investment committee if that's the proposition I was putting to them. The second issue, definitely in the UK and I think in many other jurisdictions, is that of adverse costs. And these, in the UK at least, are a very real bulwark against unmeritorious claims, especially in circumstances where if the judge disagrees with you fully, you can have indemnity costs awarded against you. And we also have in the UK something called the Arkin cap, meaning your exposure is your full commitment as a funder, including money you may have put down for security for costs. So there's very, very real disincentives to funders to be backing unmeritorious claims. The second is, again touched upon by Joshua, is that funders have undue influence on cases, how they're managed, how they're run. I think there's two elements to this. The first is the ethical perspective, and the second one, to be honest, is a very practical one. From the ethical perspective, there are laws, definitely in the UK and many other jurisdictions, ancient though they may be, of champati and maintenance that prevent funders being involved too closely in cases. And also, there's an association of litigation funders in the UK and also now Australia that has a, although voluntary code of conduct, one that has been judicially recognized as acceptable and sort of regulating the way funders act in a judicially acceptable way. We don't, therefore, control, at least reputable funders don't control claims. That's in the hands of the lawyers. The practical aspect of that being that we simply don't have the time to run claims. We're not in the business of running them. That's the job of the lawyers. I suppose where this really comes to a pinch point is the issue of settlement. And there's what some people call the first dollars issue, where funders who have put money at risk will want the return of their money quite often before claimants receive theirs. There are different regimes for this. So we heard about the Competition Appeal Tribunal regime, where there's a distribution from undistributed funds to the funder and various other mechanisms. But when it comes to settlement, there is a real risk for funders here who have claimants who do not wish to settle when an acceptable offer is put forward to them, or do wish to settle when an offer that's not very good is put to them. And that's a risk that funders take. They are not able legally to control that. Then the question normally comes, but well, if you don't control that, surely you just control the lawyers, because the lawyers are the gateway to the claimants, and the lawyers want to give you more claims so they can get more work. And again, I can tell you that's untrue, and we have to trust that lawyers are going to stand by their ethical duties and navigate the moral maze of ethics with funding in the same way as they do any other ethical issue. The final point that I was going to make was the final sort of accusation that's often leveled ethically against funders is that you make too much money. The fees are too high, and that there isn't efficient recovery for claimants, especially in class actions. This section is going to be very short. The answer is no, we don't. So I'll move on. No, I'm joking, obviously. Are the fees too high? Well, no, there are several regulatory elements to this. The first is that it's a free market economy. So there are many, many funders now in the world. There are two, indeed, on this panel. So free market economics mean that claimants and class action law firms have many options available to them now, seen particularly acutely in Australia, where funding returns have now been driven very low because there's a very saturated market, there's a very significant number of professional funders, and there's a good choice. The second way in which those fees are regulated is by the courts themselves. So again, turning to the example of Australia and many other jurisdictions, settlements are court approved, and that includes funders' fees. The same in the Competition Appeal Tribunal. Finally, I would say that in the UK, it's at the moment, well, we're currently still part of the European Union, although the big B word is going through the Parliament today, by which I mean the pricing of beer, which is currently being debated as to whether the taxes should go up or down, and obviously Brexit. But we could look to the EU for guidance. As has been discussed at length today, there's a new collective regime being proposed, which I found encouraging as a funder, because it recognized that funding was a necessary part of providing access to justice for claimants within the EU, and possibly will set out a model for a fully transparent way of funding the regulatory bodies that can bring those claims. So I think they're really the ethical issues that I wanted to address.
All right, Chris Chimicles and Stephen Weisworth, from the way that NGN practices in a concept called book building, and I must admit this concept is a novelty to me, and I'm unfamiliar with it, and I think it is unfamiliar here in Israel, so I would be appreciative if you could just give us a few words on that.
I think that to put in context the idea of book building and how it relates specifically to funding. No. Now? Great. Okay. Is this better? Wonderful. Now everyone's awake. So what NGN does in the US and in the UK are sort of distinct from a legal perspective, but from a core competency perspective, they're nearly identical. And one has what I call the heavy influence of third-party funding, whereas the other has no influence of third-party funding, and the incentives are very different. And I'm going to have to give you just a bit of brief background so that I can drive those 2 points home. NGN Group in the United States is what is called a notice and settlement administrator, and we're typically brought into a case. When there is a settlement and a judge needs assurances that the absent class members are being reached sufficiently that they feel comfortable binding those class members to the judgment. And what we do in those cases is we will take out we will either mail, we will email, we will use media, we will use all the different sorts of tricks of the trade to communicate with class members. And then myself, as the testifying notice expert, I will explain the methodologies, I will explain why we use particular forms of media, such that the judge can determine whether or not the notice program was sufficient to bind the class. If they determine it's sufficient, you get finality, and we move forward. In the UK, on the other hand, which is where we're seeing the use of third-party litigation funding intersect with NGN's core competencies, we're being hired in an opt-in regime as opposed to an opt-out regime, where we are being paid, oftentimes with third-party funding money, to go out and use all of those same skill sets, whether it's buying radio ads, television ads, email, social media, PR campaigns, to get people to opt into a litigation. And the main difference, and the reason I think third-party funding has bared on the incentives that differ in these things is when you're doing this in the United States, all the judge is concerned with understanding is whether the class members had the opportunity to participate, right? That is the term of art. That's what a judge is evaluating. And you may buy ads in a certain magazine because it reaches a huge number of people, and therefore the judge knows enough people had the opportunity to participate. That's sort of the measuring stick by which we're determining whether or not it was legally sufficient to notice. Whereas in the UK, where we're starting before a complaint has been issued, and the ultimate goal is to get as many people to sign up as possible, we're not looking at whether we bought the best media because, frankly, the proof is in the pudding, how many people signed up. And using third-party litigation, third-party money allows us to do so much more on that front end in an opt-in regime. A lot more than might be set aside under a settlement program. Even the largest and most complex of settlements, the notice budget is kind of strictly carved out. Whereas when the incentives of the funder and the incentives of the attorneys are aligned, let's get as many people to sign up as possible, you see this sort of confluence of powers that lead to something that's greater than the sum of their parts, and you're going to see more participation than you might otherwise see under the US regime. And I just think it's interesting how the funding mechanism changes the way class members are notified. And it's something I haven't seen any real study on. But I think as we have more and more UK litigation where third-party funding is the backbone of the book build, it will make for an interesting comparison. Chris.
I mean, just to build off of what Steve was saying, I mean, for somebody like Steve, one of the novel things that you can do and the way that you can approach the book build in the United Kingdom that you can't do in the United States is that somebody like Steve can use all the proverbial arrows in his quiver to go to try to sign on these claimants. And in large part, the entire litigation, a large part of the litigation strategy is predicated on the successful part of the book build, because you can convince your funder, you can have the greatest case out there. I mean, everyone's been talking about the Volkswagen case in some varying regard today. So take the Volkswagen case. You convince your funder, they say they're going to set aside 10 million pounds or whatever the number is you agree on with them. If you don't go out, if you sign up 1,000 claimants, then you're not going to move forward, whether it's IMF or Woodsford, you're not going to move forward with, filing the case because you haven't aggregated enough claimants to move forward. So, the importance of, building your book and using all the different tools at the disposal is very important. And I think we saw, and I don't think our friends are in the audience anymore, but our friends at the SPG Law Group who were here earlier today really took a novel approach with how they approached the book build in Volkswagen in the United Kingdom. And, I think they took a really interesting, unique approach in terms of, just sort of the integrated media approach that they utilized in terms of it wasn't just sort of a digital or social campaign, but utilizing radio and billboards and a PR campaign, and just really this really unique approach, sophisticated approach, and frankly one that we can't really even employ in the United States often because we're more hamstrung in terms of our approach with how we're able to even approach it in settlements in the U.S.
And that's procedural, right? Because when you're doing a book build in an opt-in jurisdiction, you're being paid by plaintiff's counsel or their funder, and you haven't issued yet, right? So the defendant doesn't have the ability to dictate. Their reputational concerns are not, they have no seat at that table, right? The notice providers in the US can only go so far because there's plenty of times we have novel ways of reaching people, and we could take out, for example, digital billboards all over the cities. They're saying, well, that's a smear campaign. But when you have third-party funding and you have an opt-in regime, they don't have a seat at that table, and it allows companies like ours to go out there and give you the full suite of services and treat a book build the way Madison Avenue would treat an advertising campaign. And you can't do that under Rule 23, the way in the sort of paradigm and the dyad that it's structured, because there's just there's A, no budget, and B, there's countervailing arguments by the defendant that it's too much. You're using an atomic bomb to kill a gnat. but we're being criticized for the lack of participation. Well, those are the reasons why in the US, you're seeing lack of participation, because we're not able to use to take Chris's phrase, arrow in our quiver to go out there. Nick?
Could you see yourself ever aggregating claims for mass arbitration? One of the things we haven't talked about today is the influx and decline of arbitration clauses and their impact on class actions in the states. Have you ever thought about that? Is that something where this would be appropriate?
Sure. So, I mean, it's the absolute same skill set. And you're right, you sort of cut out the defendant's seat at the table by doing that. I mean, I'm sure many people would kind of watch that Uber, where they aggregated all the claims and Uber was required to pay for the arbitration costs. All of a sudden, Uber wanted a class action, right? It's kind of the incentive switch from one foot to the other. But you're absolutely right. If the goal was to aggregate claims in the U.S. and then file hundreds of thousands or more or tens of thousands individual arbitrations, it would be the exact same paradigm as a opt-in jurisdiction. Yeah, good point. Noah?
I think the thing that we could take away from the panel thus far, in combination of what Josh and Simon have said and Chris and Steve have said, in combining the notion of access to justice, I think fundamentally at its core, third-party litigation funding has allowed for those people that are out there, whether it's consumers or institutional investors, to gain entry to a system that varies from country to country and jurisdiction to jurisdiction. And when you're talking about an opt-out jurisdiction versus an opt-in jurisdiction, it allows for those folks that wouldn't have ordinary access to opting into these cases, whether it be lack of education, lack of resource, no matter what type of the resource it is, that door opening and that support. So for all the reasons that Simon said, that there are ethical prophylactics in place in the considerations that litigation funders undergo when they're examining a case, the deep due diligence that gets done. I can speak from IMF's standpoint that our investment committee is extraordinarily conservative, so maybe for every 200 cases that we review, we may only accept and invest in a handful, a very small handful. And then there's incentive in the agreements that are put together with the claimants and the partnerships that are formed with the law firms for everybody to have some skin in the game. So there's incentive to take on the meritorious cases and also to not file the frivolous cases because then that would just be lost money for everybody. But my point in combining the 2 points here, the book build versus what Josh and Simon were talking about, is because it allows for other participants in the overall picture to improve their ethical standards as well. So from where I stand, and I tend to concentrate in shareholder litigation in Europe and some in the US and elsewhere, in the opt-in regimes that exist in Europe, it allows for institutional investors who have resource issues or have other higher priorities in some instances, third-party funding, that's non-recourse funding, that allows them to have the feeling of a contingency fee arrangement, the feeling, not the actuality, but the feeling of a contingency fee arrangement that they're used to in passively participating or maybe actively participating in US litigation, to allow them the opportunity and the affordability and working with expert counsel and experts in the literal fields of these litigations to gain entry into that door and be able to seek redress for monies that they may not have been actually able to go after from a resource standpoint. And from that standpoint, it allows them from one could argue from an ESG standpoint, being a good steward within the institutional investor community, if you're an institutional investor, to promote those governance concerns in a positive way internally and adhere to those mandates that you may have in-house and within the greater community as well. And in turn, the book building capability, whether it's being done with a firm with Angian or a number of the litigation funders also do book building on their own or in combination with firms like Angian for these types of cases, it gets the word out, and it allows for people to have access to that expertise and to make an educated decision and allowed to seek that type of redress.
One last question for the panel before we let you all out. Since third-party litigation funding in Israel in generally and specifically with regards to class actions is really in its infancy, if you could give the Israeli audience, whoever is left here, one good lesson, one thing that you would want us to pay attention to, maybe change from what you're used to, or maybe keep?
I guess the takeaway, and I think this is something that everybody's already doing, otherwise we wouldn't be sitting here at past 7 o'clock in the evening, is learn from your peers around the world and be open to those conversations and see what's going on in other countries. And don't be afraid to stand up, and if there's something that makes sense to implement here that's going on elsewhere or vice versa, then to take that stand and be open to those conversations.
Yeah, I agree. If you can blend different things that you've seen in different jurisdictions that work well and create your own sort of utopia system, go for it.
I'm not intimately familiar with the Israeli system of notification and distribution, but I do know that there's been considerable criticism on the way distributions are undertaken, and using sort of this register in terms of notification, to me is error for a lot of reasons. One is the money doesn't get into the hands of the people who rightfully deserve it. Two, it propagates this idea that class actions are just for the attorneys, something you essentially said earlier, and I think it's sort of an institutional failure to not use the best practices that have been clearly established around the world in order to effectuate those goals. And I think it's very easy to lean on guidance, and this is not a sales pitch, but from other jurisdictions and other professionals. I think that Israel would do well, given the volume of class actions, to maximize participation rates.
I would say allow third-party funding. Specifically, but as a serious point, I think two lessons. One, don't be afraid of collective redress and class actions. It's easy when they start to accelerate at the pace that they are in Israel and other countries to become frightened that they're overwhelming and that there'll be too much chaff and not enough wheat. That shouldn't be feared, I think, especially if you combine it with third-party funding, because that provides an additional layer of diligence to those cases, and it provides certainty for claimants and access to justice for them.
And I would just say, beware of thinking that whatever you do now is natural, and any change from that is a distortion and somehow corrupt. We tolerate huge levels of unenforced rights, incredibly limited access to justice, and so think critically about what your current system is and not treat it as sort of with a false neutrality, and how some of these innovations may in fact improve the enforcement of rights under law.
I want to thank all of you for your great stamina, for keeping up till now, and thank you very much.